This is Barry's Alma speaking for Claim School Incorporated's blogs, Alma on Insurance. Today we're going to talk about the need for insurers to use millions for defense and not pay a dime for tribute when faced with a staged accident that in law requires an elimination of coverage. In a no-fault auto insurance matter brought in New York, State Farm Fire and Casualty Company, as the plaintiff insurer, established prima facie entitlement to summary judgment by one, submitting the examination under oath transcript of defendant insured Lesie Merle, in which she testified that she primarily garaged the car involved in the accident in Far Rockaway, New York, rather than in Connecticut, and two, the affidavit of its underwriter, Christina Ardito, who established that such misrepresentation to the plaintiff's car's location was material to the decision of the insurer to insure. In State Farm Fire and Casualty versus Lesie Merle and many more, including chiropractors and doctors who allegedly treated injured individuals, the Supreme Court of New York County on April 19, 2023, found in favor of State Farm. They did so because State Farm established that defendant Brittani Watson failed to appear for an examination under oath, an EUO. Pursuant to the terms of the policy, the failure of an injured person to appear for an EUO is a defense to any claim for benefits by that person or their assignors, the doctor and chiropractor defendants. State Farm established through its claim specialist, Rika Sinha, who attested that EUO testimony led State Farm to conclude that the accident had been staged. This prima facie established plaintiff's right to deny claims arising from the accident. Therefore, the court concluded and ordered as follows. 1. The plaintiff's motion for summary judgment was granted. 2. Defendant Lesie Merle's cross-motion to vacate the default judgment entered against her was denied. 3. Plaintiff was not obligated to provide any coverage, reimbursements, or pay any monies, sums, or funds to any of the answering defendants for any and all no-fault related services for which claims and or bills have been or may in the future be submitted by the defendants to the plaintiff State Farm. 3. The answering defendants lack standing to seek or recover no-fault uninsured, underinsured, and property damage benefits. 4. The answering defendants lack standing to seek or receive no-fault reimbursements for any bills submitted by or on behalf of Lesie Merle, as she perpetrated a scheme to defraud and or fraudulently procure a policy of insurance from plaintiff by knowingly submitting an application for insurance that contained material misrepresentations of fact and false or fraudulent statements, that the alleged motor vehicle accident of November 26, 2019, which gave rise to the above-captioned lawsuit, was not the product of a covered event as defined by the applicable policy of insurance issued by the plaintiff, since the incident of November 26, 2019 was the product of a staged and or intentional event, and 6. Plaintiff by reason of no coverage, and since the alleged accident of November 26, 2019 was the product of a staged accident and or an intentional event, is not required to pay any sums, monies, damages, awards, and or benefits to any of the defendants, their agents, employees, assignors, and or heirs arising out of any current or future proceedings, all uninsured, underinsured motorist lawsuits and arbitrations and lawsuits seeking to recover no-fault benefits, third-party lawsuits and arbitrations, and all claims for property damage arising out of the alleged action of November 26, 2019 are dismissed. In my opinion, State Farm should be emulated because it refused to be cowed by a suit seeking benefits for a fraudulent staged accident and a fraudulently obtained policy of insurance. And they defeated the multiple claims created as part of that fraudulent scheme. Every insurer doing business in the state of New York or anywhere else in the country should emulate State Farm and thoroughly investigate each claim, and when fraud is suspected or established, collect the necessary evidence and refuse to pay, and be willing to litigate the issue through the trial court and into any appellate court, because it is imperative that fraudulent attempts to obtain money from insurers to which they are not entitled have to be deterred. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog post, and you will receive notice of every new blog posting, usually 5, sometimes 6 a week, and will have access to the more than 4,500 blog postings. You can also subscribe to the YouTube or to the rumble.com videos, and you will receive them as they are published. And you can subscribe, and if you find that your subscription was worthwhile, please tell your friends and colleagues so that they can also subscribe to the blog and to the videos. And if you really want to learn more about insurance, it would be useful, for a very small fee, to subscribe to my Locals community or my Substack publications. Thank you for your attention.